Hello, welcome to 43287, The History of Crime. I'm your professor, Adam Pohl, and I'd like to just talk a little bit about the course to you. This is, as you've probably already realized, an online course, a distance education course, and in order to succeed in a course such as this, above all else, you must be organized. You must keep up with the work. One of the biggest bits of advice I would give you is to keep up with the readings each week, the lesson plans, and so on, and don't leave everything to the end of the semester because it's very difficult to play catch up at that point. I would ask you to treat this as you would any other course, but instead of attending lectures at a weekly basis, I would suggest setting aside a few hours every week as your time with this particular course. Now, in talking about the history of crime and what we expect in this course, central to understanding the history of crime is the premise that crimes and punishments take place at particular times and in particular places. This means that what is classified as a crime today may differ from what it did in 1750, and as do punishments. In order to understand crime or punishment, you need to understand the context of the society in which the crime or punishment took place. To study crime in a historical context necessitates understanding the context of the society in which the crime takes place. In fact, the nature of the crime and how it is punished tells us much about that society. Let's say you download the latest James Bond film through a peer-to-peer network, and charges are brought against you for the illegal downloading of copyrighted material. The fact that such a crime exists today says something about our society, not the least of which is that we have copyright laws, that intellectual creations are protected. It also illustrates that individuals have access to personal computers and that a network such as the internet allows the fast sharing of large amounts of data. Such a crime would not have been possible in the 1950s or 1960s. Infringement of copyright material is of course not a new crime, but the context of the crime sheds light on the wider society. Why do individuals download movies instead of buying them? Are these people cheap? Is the act of downloading a statement against the nature of commercial film distribution? Does it suggest something about how the new medium of the internet file sharing has shaped how Canadians view the nature of digital copyright? Under Nova Scotian law in 1800, over 80 offences carried the death penalty. Today, there is no capital punishment under Canadian law. Canada abolished the death penalty in 1976 and removed it as a military punishment in 1998. In countries such as the United States, where the death penalty remains in effect in many states, it is imposed differently today than in the past. Executions today are public in the sense that there are witnesses to the executions, and, in theory, they are generally supposed to inflict as little pain as possible. For this reason, many states execute by a lethal injection of drugs attended by a physician rather than the older punishment of death by hanging. Executions, however, historically were always very public, usually in the most public space available, the town square. This had specific purposes of deterrence and, to a lesser and more macabre extent, entertainment. As a society's values change, so too do the actions that are considered crimes and the punishments that are meted out. As the French philosopher Michel Foucault has argued, there was a shift by the 19th century in how governments carried out punishments, from being public and brutal to being private and focused on rehabilitation. The goal of punishment changed from inflicting pain on the human body in public to trying to rehabilitate or shape the mind of the person in private. Thus, the penitentiary was created, an institution to house convicts where they could contemplate their crimes and do penance, and be reformed so that when they were released to society, they would have changed. This was better for the individual and better for the society. Examining crime and punishment in a historical context sheds light on the motivations, beliefs, and actions of persons in the past, and helps one assess the contemporary world, to see that the crimes prosecuted in Canada in 2012 might in 100 years' time seem antiquated, unjust, or even bizarre. What the laws will do for future historians, however, will be to illuminate the values and fears of our generation of Canadians.
I would like to take a moment to discuss the assignments due in the course. There will be 2 exams, that is, a midterm and a final exam. Each of these exams will be take-home. You will do them yourself and submit them to the CLUE website. There will be a document analysis. This will be you answering a series of questions based upon an historical document that relates to the course material. There will be 2 CLUE discussions. These will involve you posting discussions on the discussion portion of the CLUE website. They will be based upon a course reading. And there will also be an essay that you will complete from the Great Unsolved Mysteries in Canadian History website. This is a primary document-centered web resource that examines various true and controversial crimes in Canadian history. Each of the crimes was and remains controversial, and many questions about the crimes and those involved have remained unanswered. Each of the crimes is different. They all have commonalities in that they each tell us a great deal about the society in which the crimes occurred, one of the major themes of the course, as well as raising issues about community, social regulation, the nature of criminal justice, gender, and even cultural identity. You will have to wade through sources on the website, primary documents, many of which will be conflicting, and from these primary documents you will be arguing a case of who committed the crime and why, and what the crime tells us about the society in which it occurred. So these are the requirements or assignments that you will do for the course. There will be more information on them posted at various times on the CLUE website in advance of when the assignments are due.
Lesson 1. Administering Justice Without a State, a study of the private justice system of the Hudson's Bay Company to 1800. How do you deal with violations of rules or laws in a situation where there is no state? The example of the Hudson's Bay Company allows examination in the particular context of 17th and 18th century Rupert's Land of the problems posed in dealing with crime and punishment where there are few state structures. The Hudson's Bay Company case is an example of the interests of a private company and empire merging into one endeavor to exploit the natural resources of Canada for the benefit of a private company, while at the same time extending the power and influence of Britain. The Hudson's Bay Company, after all, governed the territory until 1870. Do you need a formal state to have laws? What if you're on a ship or in a place far from speedy communication, in an age before email or telephones? This is the case of the Hudson's Bay Company, where communication between the outpost and England took months, and so decisions, including the judging and punishment of crimes, took place on the spot, and generally without recourse to England. It is in this sense that law and governments in Hudson's Bay Company territory are often seen in terms of what life was like in the Navy or on a merchant ship. Like being on a vessel at sea, living in Hudson's Bay Company territory was far removed from the nature of civil society back in England. The territory held by the Hudson's Bay Company in Canada from 1670 to 1870, when it was transferred to Canada, was known as Rupert's Land. It was named for King Charles II's cousin, Prince Rupert. Rupert and 17 other individuals received from the King's monopoly trading rights and title to a vast region of Canada. The Hudson's Bay Company was set up as a joint stock company, meaning that individuals bought stock in the company to finance its activities and expected a share of the profits. The Hudson's Bay Company was one of the oldest joint stock companies in the world and was managed from London by the governor and a committee which was elected from among the shareholders. Until the 19th century, when it was involved in 2 colonization schemes, its primary business was fur trading. A recurring term in the assigned reading is the concept of paternalism. The authors note that their study, quote, provides an empirical foundation for the broader theorizing about the nature of non-state forms of governance and about the transition from a paternalistic to a contractual system of employee regulation. A couple of pages later they use the term disciplinary paternalism in discussing the nature of authority in trading companies and merchant marines. Paternalism in this context refers to social and political relationships in the running of the Hudson's Bay Company, particularly between the employees, company servants, and the company officers. Like a father, from the Latin pater for father, the company officer regulated the behavior of the employees. The analogy can be taken too far, but in a sense the company officer acted and had the authority of a parent over his children. The company officers, like parents, supposedly knew what was best for the employees and would discipline the workers when they stepped out of line. Pointing back to the social context in studying the history of crime, it is important to note the hierarchical nature of society and work relations in 17th and 18th century England. A person's place, by virtue of birth, if you were born to a laboring family or to a landed, perhaps even titled family, largely determined place in the society and how others treated or respected you by virtue of that social status. In the analogy the authors use, the running of the Hudson's Bay Company on the ground was a lot like the running of a ship. On a ship at sea, far from home in England, the decisions that were made were not done by vote, one person, one vote, but were hierarchical, coming down from the captain who, like a father in the family, was in charge. The author's study largely deals with the nature of discipline within the Hudson's Bay Company and how this evolved over time from a heavily paternalistic system, where officers were, in a sense, judge, jury, and executioner, to a more civilian-based system with the development of local Hudson's Bay Company post councils. Discipline in far-flung parts of the empire was a problem, and the vague instructions in the Hudson's Bay Company charter that the governor and company might impose penalties and punishments provided these were reasonable and not repugnant to the laws of England was not overly helpful, as it was not clear whether this meant English civil or military law. Indicative of prevailing views on punishments of the day, violation of the rules were often met with corporal punishment. This was less about trying to reform the character of the transgressor so that he saw the error of his ways than inflicting pain on his body in retribution and as a lesson of deterrence for those around him. When John Cartwright was accused of trying to foment rebellion at Albany Fort in 1696, the purpose of the punishment was clear. Quote, "To prevent the like for the future, and that it may be an example to others, you, John Cartwright, shall be whipped 30 stripes. Lie in irons confined, closed prisoner." One question you might ponder is what else could be done to someone who tried to stir dissent or even rebellion in an isolated part of the world far from state authorities.